Supreme Court weighs January 6th obstruction charges used against Trump. The Supreme Court justices, particularly the conservatives, on April 16th, appeared skeptical of the government's use of an Enron-era obstruction charge against January 6 defendants, including former President Donald Trump in the federal election case. Petitioner Joseph Fisher was charged under Section 1512C of the Sarbanes-Oxley Act, which was enacted after Enron executives destroyed evidence ahead of an official investigation. The conservative justices were skeptical about applying the Sarbanes-Oxley Act to January 6 and the government's use of the obstruction provision that carries a 20-year maximum sentence. Justice Samuel Alito asked if protesters obstructing a trial would violate the statute, noting that many protests have erupted within the Supreme Court, but the Justice Department has yet to charge any protesters with a single day in prison. Justice Neil Gorsuch similarly questioned if Solicitor General Elizabeth Prelogar's interpretation of the law would allow the government to give peaceful protesters 20-year prison sentences, but she said there are built-in limitations. Liberal Justice Elena Kagan, on the other hand, argued that Section 1512C(2), which bars tampering with documents, records, or objects to prevent their use in an official proceeding, is not confined to evidence spoiling on plain reading. Justice Kagan said the statute covers attempts to obstruct, influence, or impede but does not necessitate spoiling evidence. It could include obstruction of a proceeding, she said.